Minnesota has one of the most tenant-protective breaking lease frameworks in the Midwest, consistent with the state's overall heavily regulated landlord-tenant environment. The governing law is found in the Minnesota Residential Tenant Act, Minnesota Statutes Chapter 504B, along with the Minnesota Human Rights Act and general contract principles. If you're a landlord or tenant in Minnesota, the state provides a detailed statutory framework with strong tenant protections that significantly affect how broken leases are handled. Let's start with the landlord's duty to mitigate damages. Minnesota law clearly requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. This duty is well established through both statutory interpretation and Minnesota case law. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent. The landlord must take reasonable steps: advertising, showing, and accepting a qualified replacement tenant. Minnesota courts take the mitigation duty seriously. Landlords who make no effort or who delay unreasonably will see the departing tenant's liability substantially reduced or eliminated. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs, advertising, cleaning, make-ready work. Once a replacement tenant moves in and begins paying rent, the departing tenant's obligation ends. If the landlord re-rents at a lower rate, the departing tenant may be liable for the difference through the original lease term, but only if the lower rate reflects market conditions rather than the landlord's failure to market effectively. Early termination fees in Minnesota must be reasonable. Minnesota's Consumer Protection Framework, including the Prevention of Consumer Fraud Act and the Uniform Deceptive Trade Practices Act, provides tools for challenging fees that are excessive or unconscionable. A fee of 1 to 2 months' rent with reasonable notice is typical and generally enforceable. Fees that approach the full remaining lease amount face serious challenge in Minnesota's tenant-protective legal environment. Minnesota also has specific provisions regarding the landlord's obligation to disclose screening criteria and rejection reasons within 14 days, and this transparency requirement extends to the re-rental process after a broken lease. When the landlord is screening replacement tenants, the same disclosure and notification obligations apply. Military members have the right to break a lease under the SCRA. Minnesota's military population is relatively limited. The Minnesota National Guard has facilities throughout the state, but there are no major active duty installations. However, the SCRA applies to any service member renting in Minnesota. Minnesota has enacted comprehensive protections for victims of domestic violence, sexual assault, and harassment that allow early lease termination. Under Minnesota Statutes Section 504B.206, a tenant who is a victim of domestic abuse, criminal sexual conduct, or harassment can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation can include a copy of a valid order for protection, a no-contact order, or a written report from a qualified third party, such as a law enforcement officer, domestic abuse advocate, or healthcare provider. The tenant must provide at least 1 month's written notice, or a shorter period if remaining poses an immediate threat to safety. When a domestic violence victim terminates under Section 504B.206, the tenant is responsible for rent through the termination date plus 1 additional month's rent, unless the tenant's safety requires immediate departure, in which case the additional month may be waived. The landlord cannot charge an early termination fee beyond this amount. The security deposit is handled according to standard rules, returned within 21 days. Minnesota's provision includes strong privacy and anti-retaliation protections. The landlord must keep all documentation confidential. The landlord cannot disclose the tenant's status as a victim, and the landlord cannot consider the domestic violence termination as a negative factor in any future rental decision. Given Minnesota's broad fair housing protections, which include status with regard to public assistance, the anti-retaliation framework is actively enforced. Tenants in Minnesota may break a lease if the landlord fails to maintain habitable conditions. Under Section 504B.161, the landlord has a duty to maintain the premises in reasonable repair and in compliance with applicable health and safety codes. If the landlord fails to address serious deficiencies after receiving proper notice, the tenant has remedies including lease termination. Minnesota also has specific provisions regarding essential services. Under Section 504B.221, if the landlord fails to provide essential services, heat, running water, hot water, electricity, gas, or sanitation, the tenant has remedies that can include rent abatement, obtaining substitute services, and lease termination. Minnesota's extreme winters make heating failures particularly urgent. A landlord who fails to restore heat during a Minnesota winter creates an immediate health and safety emergency. Minnesota's rent escrow process, under Section 504B.385, provides tenants with an intermediate remedy before termination. The tenant can deposit rent with the court rather than paying the landlord, and the court can order repairs, reduce rent, or allow the tenant to terminate. While rent escrow is a separate remedy from lease termination, it often leads to termination if the landlord refuses to comply with court-ordered repairs. Minneapolis and St. Paul add additional protections on top of state law. Minneapolis's Renters' Rights Ordinance includes provisions that may affect how broken leases are processed within the city. St. Paul's tenant protections, including the 3% rent cap, create additional considerations. Landlords in both cities should verify current local requirements. From a practical standpoint, Minnesota's rental market is concentrated in the Twin Cities metro, with secondary markets scattered across the state. The Twin Cities, Minneapolis and St. Paul, have one of the strongest rental markets in the Midwest. When a tenant breaks a lease in the Twin Cities, re-rental is typically quick in desirable areas, often 2 to 4 weeks. Minneapolis neighborhoods like Northeast, Uptown, North Loop, and Linden Hills have strong demand. St. Paul's Highland Park, Cathedral Hill, and Mac Groveland areas are similarly competitive. The Twin Cities suburbs, Bloomington, Eden Prairie, Plymouth, Maple Grove, Eagan, have strong markets with quick re-rental for well-maintained properties. Rochester, home to Mayo Clinic, has an extremely strong market where broken leases are filled quickly. The steady flow of healthcare professionals and patients seeking extended-stay housing creates deep demand. St. Cloud, Duluth, Mankato, and Moorhead have more moderate markets. College towns, including the Twin Cities university areas, Mankato and Moorhead, have seasonal dynamics tied to the academic calendar. One best practice for Minnesota landlords: structure your early termination clause to comply with Minnesota's consumer protection framework. Keep fees reasonable, 1 to 2 months rent, and include a clear notice period. Minnesota courts will scrutinize excessive fees, and the state's active tenant advocacy organizations are quick to challenge unfair provisions. Another best practice: begin re-rental efforts immediately and document every step. Minnesota's strong mitigation duty means your documentation is critical. The state's tenant protective courts expect landlords to act promptly and diligently. A third best practice: have a thorough process for handling domestic violence terminations under Section 504B.206. Train your staff on the documentation requirements, notice periods, the additional month's rent calculation, and the strict confidentiality obligations. Minnesota's enforcement environment is active, and fair housing organizations regularly pursue complaints. Minnesota limits the security deposit to 1 month's rent. The deposit must be returned within 21 days of the tenant vacating, with an itemized statement of deductions. Interest must be paid on deposits held more than 5 months. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Minnesota breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.